Good afternoon, everyone. Thank you so much for joining me today for our webinar that is going to discuss, does your estate plan need a tune-up? I do have that it is 11:59 on the clock. I'll give just a minute or two for the last few folks that are hopping on to the webinar, and then we'll get started immediately because I love to be respectful of other people's time, and I do thank you all so much for attending. Give it just a couple more seconds, and I'll go ahead and start the presentation. Alrighty, we'll get started here. Once again, thank you so much for joining me. My name is Tanieka Thompson Mungo, and I am the owner and managing attorney of the Thompson Mungo firm, where we assist our clients with planning for and protecting their legacy. Thank you for joining us for our presentation on whether or not it is time to update or give your estate plan a tune-up. So we'll move forward. Thank you for joining us. And this is such a very important topic to discuss. And it's not something that we really are mindful of on a regular basis. So it's such a wonderful thing that you all are here today to learn when it would be a good time to start thinking, you know what? I wonder if it's time for me to revise my estate planning documents based on this major life change that has happened to me. So have you created an estate plan yet to protect your loved ones in the event that something happens to you? That's great, but it's still important to keep in mind that it's important to review it every now and again, and also based on the changes in our lives. As you get older, as your kids get older, as your grandkids grow, your life circumstances change. And it's likely that your estate plan will also need to be updated to reflect those changes. So before we dive in, let's review just a few of, probably around 5 of the most important estate planning documents that you should have in your estate plan. The first document that you should really have in your estate plan is a durable financial power of attorney. So just to kind of give a broad overview of the purpose of that document, a financial power of attorney is a document that appoints an individual to manage your finances in the event that you're injured or unable to manage them for yourself. The durable financial power of attorney is a simple way to allow someone else to manage your finances in the event that you become incapacitated or you're just unavailable to handle a particular matter, and you're not able to make those decisions at that time. The power is granted in this specific document, and it's not only useful, but it can really be helpful to your family in the time of crisis. So it is better to have it in advance and executed than need it and not be able to get that document put in place at that time. Secondly, is a durable healthcare power of attorney, but in the state of Georgia, it's referred to as an advanced healthcare directive. A healthcare power of attorney is a document that appoints an individual to receive healthcare information and make medical decisions on your behalf when you're unable to do so. It's similar to a durable power of attorney, but it's a little different because this speaks specifically to healthcare decisions, and you will nominate an agent or multiple agents that can have that authority to make that decision on your behalf. It's important to have someone in place and also to share with them what your preferences are as it relates to your healthcare matters, so that they understand what decisions you would make in the event that you're not able to make those decisions on your own. The third document is an advance directive, and this is more commonly referred to as a living will. This document expresses your wishes in the event that you become incapacitated. In Georgia, the Advanced Healthcare Directive is a more of a combo document with a healthcare power of attorney and the advance directive all in one. So it gives you the opportunity to be able to voice those choices in the event that you're not able to do so and you're incapacitated. So essentially with a living will, it allows you to make your decisions and to direct which types of life-sustaining treatments are acceptable for you. And also, if you'd like to have certain treatments if you're suffering from a terminal illness. So it gives you a voice when you don't have one in that moment. Next is the last will and testament, which is most commonly what most people will think of when they think of estate planning, and not necessarily the other documents previously mentioned, which address incapacity planning. But the last will and testament speaks to when you pass away. So simply put, it determines who gets your assets at the time of your passing. A last will and testament is a legal document that expresses what you want to be done with your property, including your money after your death. So a living will is it's different in that it speaks to what happens as far as your care if you're terminally ill, but a last will and testament speaks to what happens to your assets in the event of your passing. So it's so very important to understand the difference between those two, but a lot of people will ordinarily refer to them as the same. The next thing to think about is also a personal property memorandum. Are there a number of items that you have and you hold so very dear and personal and just they have significant value to you that you would like to provide to other people at the time of your passing? It's so important to document those things. And this can occur either through your will or even through a personal property memorandum. And this is a document that details how you want your personal effects to be distributed. It's a very flexible and easy to use document that permits you to freely put together a list of your smaller, more tangible items, including your clothing, your jewelry, your pieces of art, even family heirlooms or some memorabilia and things of that nature to be given to your intended beneficiary. It's a separate document from your will. Or even your trust. And it is one that you will be able to prepare on your own, and you can make changes to it as many times as you wish without the need for a witness or even a notary. So this is a very, very helpful tool to provide for other individuals or to provide gifts to specific people without having to make a significant change to your last will and testament. This is such a very, very important question, and I get asked this quite frequently. How often should you review your plan? Now, it's so very personal and dependent on your personal circumstances. However, we recommend that you review and update your plan at least every 3 to 5 years. In addition, we recommend that you update your plan whenever you experience a significant life change. And there are a number of significant life changes that occur more commonly that we would think that would be considered as significant life changes that would require that you at least review and revise your estate planning documents just to make sure that they're reflective of your current wishes in that moment of your life. So here we will get started on discussing those particular changes. The first one is marriage. Marriage is a huge event, and it is a beautiful event, and it definitely triggers the thought that it is a good time to at least revise your estate planning documents, because they may not necessarily include your spouse at that time. So if your estate planning documents, such as your will, do not list your spouse as a beneficiary, it may be time to update those documents to reflect that you are married, and also that you are making certain gifts or provisions for your spouse in your estate planning, and it'll be more reflective of your current circumstances. So in the event that you do get married, that is an excellent time to update those documents. And to the other end of the spectrum, divorce. So in the event that you are getting a divorce, or you have already divorced your former spouse, I mean, it is a great time to update your estate plan, just to make sure that it is reflective of your wishes at that time. Are you going to remove your ex-spouse from your estate plan, or are you still going to leave provisions or gifts to them in your will? Also, it's a great time to review your insurance policies after a divorce. You know, is your spouse still going to remain a designated beneficiary on your insurance policy? Also, with your retirement accounts, that's a great time to think and start looking at those things as well. In addition to any other accounts, if they're designated as a beneficiary, anything that can have a beneficiary designated at the time of a divorce is a great time to definitely start making sure that all those documents are accurately reflecting whom it is that you would like to receive those particular gifts. Next, the birth of a child, which is such a very fun endeavor, to say the least. So having children would definitely trigger the need to update your estate planning. So definitely, if you have a child or adopt a child, or have additional grandchildren that are born, and you have made provisions for grandchildren in your estate planning documents, it may be a time, or it may trigger the need to at least revise your estate planning documents. So definitely keep that in mind. As much as joyful as it is to welcome children into this world, it is definitely time to make sure that our documents are correctly reflecting how we would like our estate to be handled in the event of our passing. Next is a big move. So moving across state, or moving actually to another state or across country, it's definitely a good time to consider whether or not it will be time to update your estate planning documents. Taking into consideration whether or not your documents are recognized in the state that you're moving to. Are there different laws in that state? Are there different requirements as it relates to estate planning documents in that state? So there's so many things to take into consideration when you are moving to a different state, and to determine whether or not it is an appropriate time to update your estate planning documents. If your children have now grown to become very self-sustaining adults, drafting estate planning documents while your children are still very young and minors, and there is a need to have a guardian named in the documents, I mean, that is very important to have in place while your children are still young. However, when your children grow up, and there is no longer a need to have those kinds of notations in your documents, it's important to update it to now reflect what it is that you'd like to happen to your belongings, or how you'd like your assets distributed to your children at that time when they are adults. At that point, the formative years are over, and now you know how responsible your children are, or even how irresponsible they may be, because it does happen on both sides. The occurrence of a death, as unfortunate and as sad as it may be, death is a part of life. So a death or a change in circumstances of a guardian or even an agent, it's important at that point in time to update documents to make sure that it's reflective of the current people in your life that are available to serve in that role. Also, if there's a change in a relationship with a named agent, that is a very appropriate time to update your documents to change who is named as an agent to represent your interests. If you no longer trust that person, there is no need to keep that person listed on your documents as an agent if you do not intend for them to serve in that role. So that is something that I would recommend that you update immediately, just to ensure that that person doesn't do any damage or any potential harm to you. And even in the event of your untimely passing, if that happens, that they're not the person entrusted with managing your estate when there was a lack of trust in that relationship. Also, changes in the number of dependents, such as adding or caring for an adult child. If a child becomes dependent on you or they're disabled and you're now having to care for them, that is very much so an important time to think about your estate planning documents and the consequences of your estate planning documents. So say, for example, you have a child that you've adopted that has special needs and you are wanting to provide for their care later on in life, it would be best to make sure that their gifts are designated in a special way to ensure that they do not lose their benefits. So it's so very important to keep in mind that dependent on the circumstances of all the people around you that you care for and you love, that your documents are reflective of the wishes that you would like to be carried out at the time of your passing. If there's a large purchase, which we all love large purchases, they're all exciting, such as buying a home or any other large asset, these purchases have such significant financial and tax implications, and they should be addressed in your estate plan. So it's definitely something to be mindful of in the event that you are making a large purchase, to ensure that your estate planning documents are reflective of those things. And even in the event that you do purchase a large asset, to include it in your estate planning, because I've seen it time and time again where folks have executed their estate planning document, purchased additional property, but did not go back and revise their documents to ensure that that particular property or large asset was transferred to the designated individual, and it may have fallen in their residue, which the residue goes to an unintended beneficiary. So it's so very important to keep in mind that if you are making large purchases or adding to your wealth, to make sure that your documents are always up to date to reflect what your wishes are as it relates to those particular assets. This goes hand in hand with the last slide that we just discussed. So large increases or even decreases in the values of certain assets, such as investments, that definitely changes valuation of an estate or even of what you own at that time. So understanding how the value or the loss in value that an asset is sustaining, what does that mean for your estate? If the value decreases, how does that impact your estate? If the value of an asset increases, how does it impact the value of your estate? So this is definitely something to keep in mind as the time moves forward, and especially in this day and age with the evolution of cryptocurrency and NFTs and things of that nature, it is just so very important to be mindful of capturing the value of those particular assets. A change in your trustee. So with this particular topic, it could happen in the event that your agent or the person that you've designated or nominated has passed away, or they're no longer able to serve. Maybe they don't have the time, maybe they don't have the flexibility to be able to serve in that role. It could even be a matter that they've passed away. Those things do happen. It's a part of life, or even it could be, as previously mentioned, a change in the relationship. So at that time, it is definitely important to be sure to update your documents to reflect the change that needs to occur. Because if this person is not able to serve in that role, and God forbid something were to happen to you, now it just kind of puts your affairs in limbo, and you don't want that to happen. You want it to continue to occur in the way that you have designated for things to occur. Business changes. So starting a business, selling a business, and especially in the last couple years of having to deal with the COVID pandemic and all that we've endured, a lot of people have started businesses. So it's so very important at this time to start understanding, well, what does this mean for my estate planning? Do I need to change things? Do I need to adjust or have more sophisticated planning for my estate due to my starting this business? A lot of people have started new businesses, so it's definitely a good time to assess your estate planning and to ensure that your interests are protected, and also so that it's transferred in the way that you would like for that to occur. There are a number of other circumstances that would trigger the need to update your estate planning documents. These include illness, a death, a disability of a family member. So it could be a spouse that is now disabled, and you would need to update your estate planning documents in the event that you pass before your spouse, to ensure that they don't lose their benefits, or to make sure that you provide for their care in the event that you pass first. So there's so many things to take into consideration. So a change in your life insurance could even trigger the need to update estate planning documents, or even long-term care insurance coverage changes would trigger that as well. In the event that your spouse receives a large inheritance, that could even trigger the need to update your estate planning documents. Changes in the laws. That's one thing that a lot of us don't really think about, because, once we've got it done, we're done, and that's off the list. But there are things that do change that are outside of our control that we may need to address in our estate planning documents. And that could even be the federal or state laws that cover the taxes and investments as it relates to our assets. I have run through this presentation really, really quickly, but it's something that is just so very near and dear to me that, it's very important to ensure that we get get the changes in our life addressed via our estate planning, to ensure that we are providing for our family, and also to make sure that we're protecting our assets. Now, I will go ahead and stop the slides to take a look at the chat to see questions that have been posted as it relates to our estate planning. So just a moment here, let me pull up the chat. Okay, so I do have a question here, and it states, what about the death of a family member that you have provided for in your estate planning? Well, I would encourage you to update your estate planning documents at that time if you have a family member that has passed away that you've provided for in your estate planning documents. If it's a very significant asset that you've gifted to that particular individual and you'd prefer that it go in a different direction, that is definitely a great time to update your estate planning documents. I hope that answers your question. We'll go to this next one here. This is very similar to something that we previously discussed just a few minutes ago. It reads, and I'm going to paraphrase just a bit here. I have a child that is now disabled, and I am providing for their care. They are receiving benefits and I want to leave my estate to them, but I want to make sure that they don't lose those benefits. Well, this question goes here into a little bit of the special needs planning realm. And it speaks to the need to ensure that, the gifts that you are providing to that particular beneficiary do not result in that family member losing their government need-based benefits. So it may be a need to do a little bit more sophisticated planning via special needs trust or even other planning tools that would assist you in ensuring that you do not gift anything to that particular family member that would allow for them to lose their benefits. Now, there are a lot of other topics that we could have covered in this presentation that are just as important as discussing divorce, having additional children and moving and things of that nature. And it could even be the fact of having children with special needs. I know I talk about that quite a bit, but it's just such a very important topic that I don't think a lot of people discuss, or a lot of people are not aware of the need to plan for individuals with special needs and to make sure that at least we have someone named to care for them in the event that we pass away, because there are a lot of parents that are caring for adult children that they have that they don't have someone identified to care for them in the event of their passing, or even in the event of their incapacity. Who's going to be responsible for making decisions for that now disabled adult child? Who's going to be responsible for the finances? All of those things are very important and should be addressed in your estate planning documents. So it would be important to at least schedule an appointment to at least assess what the needs may be for you and for your family prior to going another year without reviewing those documents and just assuming that everything will be okay. So with that said, I'm going to wrap up this presentation, but I do want to encourage you to at least get your estate planning documents reviewed every 3 to 5 years if you haven't had any significant life changes. However, if you have made significant purchases, had children, gotten married, gotten divorced, or there's a change in the relationships as it relates to the individuals that are named in your documents, those are triggering events that should encourage you to at least get your documents reviewed and updated, and to make sure that they are reflective of what your current needs are. So thank you all so much for joining us today for our presentation. And if you have any questions, you're welcome to contact our office. Our office number is 678-855-6002. And we are located in McDonough, Georgia. And you're welcome to schedule an appointment either virtually or via telephone. Granted, COVID is a little rampant right now, so we're encouraging virtual meetings to ensure that everyone remains safe. So we look forward to meeting with you and to discussing your needs and to getting that planning done. So thank you again, and we look forward to seeing you at our next webinar. Have a good one.